Now we need to talk about the structure of the federal courts. There are two kinds of federal courts that were created by Congress to handle cases that the Supreme Court did not need to decide. Remember that Article 3 gives the Congress the right to set up courts, all right, that would help the Supreme Court, because only the Supreme Court is the one that is actually set up by the U.S. Constitution. There are constitutional courts which exercise judicial powers that are found in Article 3. Judges are given constitutional protection. In other words, in those constitutional courts, judges serve during good behavior. Their salaries are not reduced while in office, and your examples would be the 94 district courts and the 12 courts of appeals. The legislative courts are different. The legislative courts are set up based on Article 1, Section 8. They are created by Congress for specialized purposes. The judges have fixed terms. The judges can be removed. There's no salary protection. And a good example would be the Court of Military Appeals. Our next issue is selecting justices before we talk about the jurisdiction of the court. Studies link the link between party and liberalism versus conservatism is there, mainly on issues involving civil liberties, criminal justice, and economic regulations. Judicial behavior, the party background has that strong effect. Other factors also shape court decisions: facts of the case, prior rulings, and legal arguments. Prior rulings are known as precedent. There's no way really to predict how a judge will behave. We just have to hope that they uphold the law and not decide a case strictly on their own ideological beliefs. Senatorial courtesy is a heavy weight to preferences. Heavy weight is given to state senators for giving preferences for judicial appointments. Appointees for federal courts are reviewed by senators from that state. If the senators are of the president's party, all right, it's especially important because it's particularly good for U.S. district courts within your own circuit. The litmus test is also used. It's where you're not using senatorial courtesy. The litmus test has been described as a test of ideological purity. Presidents seek judicial appointees who share their own political ideologies, be it liberal or conservative or moderate. This has caused different circuits to come to different rulings about similar cases. It also raises the concern that ideological tests are too dominant, that they have led to a sharp drop in the percentage of nominees to federal appeals courts who are confirmed. It has been used as a reason for rejecting a Supreme Court nominee, especially in the area of abortion. A judicial nominee's view on abortion is the chief reason for the use of the litmus test becoming paramount. It's also being used in cases involving affirmative action, such as the Ninth Circuit being liberal in that issue and the Fifth Circuit being the most conservative. The threat of a filibuster aimed at blocking Senate confirmation has led to a situation where the nominee must have the support of at least 60 senators to guarantee that a cloture vote would stop a threatened filibuster. This has led to a great deal of legislative maneuvering with controversial nominees. Can there ever be an ideologically neutral criteria? That's a question that we can't answer at this point in time. We know that the federal courts have certain types of jurisdiction. Okay, in this country we have what is known as a dual court system. We have state and federal courts. Each of the 50 states, as well as the District of Columbia, has its own fully developed independent system of courts. But every court has a type of jurisdiction. Jurisdiction is for the federal government is a limited type of jurisdiction, but it is also for the state courts because it's the power of a court to hear a case. Under Article 3, Section 1 of the U.S. Constitution, the jurisdiction of the federal courts to hear cases involve either a federal question or a diversity of citizenship. Federal question arises when a case based, at least in part, on the U.S. Constitution, a treaty, or a federal statute. Diversity of citizenship exists when the parties to a lawsuit are from different states or when the suit involves a U.S. citizen and a government or a citizen from a foreign country. The amount in controversy must be at least $75,000 before a federal court can take jurisdiction in a diversity case. There's also the issue of standing, and we'll get to that in a minute. Okay. Keep in mind that the only way to get a case, to the U.S. Supreme Court is through a petition and the court ordering a writ of certiorari. You also have the situation where some cases can be tried in either federal or state court. The example in your book is, if both federal and state laws have been broken, you have dual sovereignty, such as in the Rodney King case. Each government has the right to enact laws, and neither can block prosecution out of sympathy for the accused. Some cases that begin in state courts can also be appealed to the Supreme Court, and sometimes overturning state court decisions has been the issue. Controversies between two state governments can be heard only by the Supreme Court, in which it has original jurisdiction where the case would originate there. You really need to refer to the chart in your book on page, I believe it's 431. The chart is also here in the PowerPoint. Here we have getting to court, okay? All right, ways in which, or your route to the U.S. Supreme Court, all right? Most federal cases will begin in district court. The Supreme Court will reject all but a few of the applications for certiorari. Costs of appeal are very, very high. Financial costs, including filing, recording, attorney's fees, etc. But it can be lowered for some. First of all, if your plaintiff is indigent, the cost can be paid by the government, and the plaintiff would file what is known as an in forma pauperis petition. It must be granted by the court, all right? It's just not automatic. Indigent defendants in a criminal trial need legal counsel, and that's provided by the government at no charge. Sometimes you can go to interest groups such as the American Civil Liberties Union, and they'll pay for the cost of the trial. The example here in your book is the NAACP, bringing the class action suit that resulted in the 1954 Brown versus Board of Education decision. Cost in terms of time is also high, but that can't be mitigated. It takes a while for a case to get through the Supreme Court, anywhere from 3 to 5 years. You also have the issue of fee shifting, where typically a party will pay its own legal expenses, but there are some situations in which the losing defendant pays the plaintiff's expenses. A lot of times that's really set by statute. You need to look at the examples in your book. So let's look at standing. Standing to sue, or a sufficient stake in a matter to justify bringing a suit. That's standing. The party bringing the suit must have suffered harm or have been threatened by a harm as a result of the action that led to the dispute in question. Standing to sue also requires that the controversy at issue be justiciable. A justiciable controversy is a controversy that's real and substantial, as opposed to something that's hypothetical or academic. In other words, a court will not give advisory opinions on hypothetical questions. Class action suits can be brought on behalf of all similarly situated persons. The number of class action suits has increased because there were financial incentives to bringing the suit and because Congress was not meeting new concerns. In 1974, the Supreme Court tightened the rules on these suits for federal courts, though many state courts remain accessible. Big class action suits affect how courts make public policy, such as suits involving asbestos and silicone breast implants. There are examples in your textbook. Please take a look at them. We need to look at the Supreme Court at work. The Supreme Court begins its regular annual term on the first Monday in October and usually adjourns in late June or early July of the next year. Special sessions may be held after the regular term is over, but only a few cases are decided in this way. More commonly, cases are carried over until the next regular session. Of the total number of cases that are decided each year, those reviewed by the Supreme Court represent less than 0.5%. Because the Supreme Court exercises a great deal of discretion over the types of cases it hears, it can influence the nation's policies by issuing decisions in some type of cases and refusing to hear appeals in others, thereby allowing lower court decisions to stand. The Supreme Court has decided issues involving capital punishment, affirmative action, religious freedom, assisted suicide, abortion, busing, term limits for congresspersons, sexual harassments, pornography, states' rights, limits on federal jurisdiction, and numerous other matters with significant consequences for the nation. What cases reach the court? There is no absolute right of appeal to the U.S. Supreme Court. The court's appellate jurisdiction is almost entirely discretionary. The court can choose which cases it will decide. Certain factors bear on the decision. Factors that bear on the decision include whether a legal question has been decided differently by various lower courts and needs resolution by the highest court, whether a lower court's decision conflicts with an existing Supreme Court ruling, and whether the issue could have significance beyond the parties to the dispute. Another factor is whether the Solicitor General is pressuring the court to take a case. The Solicitor General, a high-ranking presidential appointee within the Justice Department, represents the national government in the Supreme Court and promotes presidential policies in the courts. He or she decides what cases the government should ask the Supreme Court to review and what position the government should take in cases before the court. The influence wielded by Solicitor Generals over the court's decision-making has led some to refer to the Solicitor General as the 10th Justice. Granting petitions for review is known as the writ of certiorari. The writ orders a lower court to send the Supreme Court a record of the case for review. More than 90% of the petitions for writ of certiorari are denied. A denial is not a decision on the merits of the case, nor does it indicate agreement with the lower court's opinion. The denial of the writ has no value as a precedent. The court will not issue a writ unless at least 4 justices approve of it. This is called the Rule of 4. Deciding cases. Once the Supreme Court grants the certiorari in a particular case, the justices do extensive research on the legal issues and facts involved in the case. Each justice is entitled to 4 law clerks, who undertake much of the research and preliminary drafting necessary for the justice to form an opinion. The court normally does not hear any evidence, as is true with all appeals courts. The court's consideration of a case is based on the abstracts, the record, and the briefs. The attorneys are permitted to make oral arguments. The court hears oral arguments, on Mondays, Tuesdays, Wednesdays, and sometimes Thursdays from the first week in October to the end of April. All statements and the justices' questions are tape recorded during these sessions. Lawyers addressing the Supreme Court can be and often are questioned by the justices during oral argument. Justices meet and discuss and vote on cases in conference held each Wednesday and Friday throughout the term. The conferences are strictly private, so no stenographers, tape recorders, or video cameras are allowed. In addition to deciding cases currently before the court, the justices decide which new petitions for certiorari to grant. Remember the rule of 4. The court will not issue a writ